This is Bloomberg Law with June Grasso from Bloomberg Radio.
A federal judge has ruled that the Trump administration must restore 34 educational panels about slavery at a site in Philadelphia where George Washington lived as president. Judge Cynthia Roof compared the display's removal last month by the National Park Service to the government mind control employed in George Orwell's novel 1984. The judge found that the federal government does not have the power it claims, quote, to dissemble and disassemble historical truths when it has some domain over historical facts. Joining me is Cheryl Cashin, a professor at Georgetown Law. What's your reaction to this 40-page opinion by Judge Roof?
Oh, well, I think it's a beautiful piece of Americana now because, first of all, she's a George W. Bush appointee, and she issues a preliminary injunction basically saying to a sitting president, you don't get to be Orwellian. You don't get to be like the Ministry of Truth in this science fiction novel and impose your view on objective facts. We have a complicated history. That history includes slavery. Yes, our greatest founder was a slave owner. We're not going to hide that. And we're going to learn from that history. I actually found there were passages in the opinion that were quite patriotic and soaring. So I'm very appreciative of what she did in this Black History Month and on President's Day.
You can't get past the symbolism there.
No.
When she criticized the Trump administration, she said, truth is no longer self-evident, but rather the property of the elected chief magistrate at his whim to be scraped clean, hidden, or overwritten. Why? Solely because as defendant state, it has the power. What was the Trump administration's defense to taking these panels down?
It's only defense. And first of all, it was the National Park Service that was sued. They're the ones who took them down, but their only defense, and the judge points to this, seemed to be that Donald Trump issued an executive order requiring things like this. That was it. They didn't offer any reasons for it. And I think it's important to bring out to your listeners exactly what these 34 panels covered, the stories they covered. And I greatly appreciated the judges doing this. They covered the fact that the Washingtons in the president's house brought 9 enslaved people there. And she named them in the opinion, and I think it's worth us taking a quick moment to name them. She named them all. Oni Judge, Martha Washington's maid, Austin, her brother, Christopher Shields, the president's valet, Giles, the carriage driver, Hercules Posey, a supremely talented chef to the Washingtons, Joe Richardson, the coachman, Maul, Martha Washington's nanny for the grandchildren, Paris, a stable worker, and Richmond, who was the son of Hercules and a chimney sweep. The complicated history that these 34 panels told was that George Washington, our first founder, would rotate these 9 people out every 6 months to evade a law that Quaker abolitionists agitated for and won that would allow them after 6 months to petition for freedom. He didn't want them to be free. Okay, that's complicated, but it's true. The other story that I think that the White House was probably uncomfortable with was the story of Oni Judge, a freckle-faced, bushy-haired teenager who escaped, probably with the help of a free Black community. Overwhelmingly, the Black people in the city at that time were free. Hundreds and hundreds of Black people. And in fact, the Black community was blocks away from the president's house. And this young teenager escapes. It's beyond Martha's imagination that the person who catered to her every need would want to leave her. And she basically, I think, more than anyone, put pressure on George Washington to find her. George Washington, as president, spends 2 years trying to recapture her and does not succeed. And so they're outwitted by this young Black teenager who desperately wanted to be free and lived free for the next 50 years. And that's the story that the Trump administration suppressed. And the judge, to her credit, talked about how the display recognized Oni Judge and her fierce struggle for freedom, and how it represented the country's progress away from the horrors of slavery, where everybody could live with life, liberty, and the pursuit of happiness.
What was the legal basis for the judge's ruling?
For years, I taught administrative law, right? A basic tenet of administrative law is that government does not get to reverse itself on a whim without explanation, particularly when a policy has been in place. There were several pieces of congressional legislation. There was a legislation going back to 1948 creating this National Independence Park. There was a 2006 law in which Congress encouraged the telling of this complicated story. And as we discussed, they didn't offer any explanation for why you had this extreme reversal of taking down exhibits that told this complicated history. So that was arbitrary and capricious. That's one thing. The city of Philadelphia also had a statutory right to be consulted on any changes at the president's house. They paid for this project. They paid for these interpretations, these panels, the videos telling this story. They invested $5 million in the project, right? So they had a statutory expectation and a right to be consulted before any changes were made. That law was violated, right? So arbitrary and capricious under administrative law. Also, it was a breach of separation of powers. The court made it abundantly clear that the President of the United States does not get to, by executive order, frankly, executive fiat, authorize an agency to violate a law Congress passed, right? So there's that. The court also alluded to federalism. Judicial conservatives generally tend to like the idea of federalism, of allowing local and state control, the 10th Amendment values. Well, the Governor Shapiro, filed an amicus brief saying, we supported telling our public this complicated history, and the city supported, and certainly, the Black cultural institutions that helped shape the content, they were outraged that, this interesting, complicated history where African Americans are present and featured was ripped out with no explanation. So all of those reasons the judge brought to bear.
So the judge issued an injunction ordering the government to restore the panels, but she didn't give them a date certain. And the government is going to appeal the ruling. What do you think their chances are on appeal, since we don't really know what their argument was in the first place?
I think this is an airtight case. I want to say hundreds of lawsuits have been filed to stop the Trump administration from violating law. There's more than 150 orders have been issued to the Trump administration, blocking them from doing something that's unlawful, right? And I want to applaud, the federal courts, particularly the trial courts, are checking this presidency and upholding the rule of law. I do not see how the Court of Appeals, even if they get lucky and get a panel that's all conservative judges, it's pretty airtight. There are two statutes that make it clear that the city, first of all, the city owns the land where this presidential site is. There's a federal law that sanctioned this cooperative arrangements, and the federal government has entered into a series of cooperative arrangements. They took and benefited from the $5 million that Philadelphia put forth to put up this display. And by the statute, they were entitled to be consulted on any changes. So it's pretty airtight. I do not see how any judge that's operating with intellectual integrity to the rule of law would uphold this. Violates separation of powers, Congress's intent, violates principles of federalism, violates principles of vested interest. And also, frankly, in a lot of these federal court opinions, there are allusions to what's morally right. You know, this judge used the literary reference of 1984, George Orwell's 1984, right? She quoted explicitly from it. There's a law, and there's also what ordinary people would recognize as morally right. Let me underscore this. And it's part because I'm more familiar with this. I'm a Black American, and I'm a law professor, and I've written a lot of books in which I play an amateur historian. This effort, the removal of these panels here, was part of a larger despotic erasure of Black history by this administration, right? He issues this executive order last March of 2025, which basically tells every single agency in the government to scrub the government of references that put any American, including colonial Americans, in a bad light. They've purged any reference to Black Americans and their contributions from websites. They have threatened any school district that has Black or ethnic studies in their curriculum with withholding of money. It's just clear that Black American history and the African American struggle for freedom, for some reason, they seem to feel that puts particularly white leaders of the past in a bad light. I actually happen to have a very patriotic view, like the judge did. Like, there's nothing more patriotic than people of all colors and genders claiming the words of the Declaration of Independence as theirs. I'm a proud American. I believe in our self-evident truths. Let me tell my story of how I live as an American. And that's what's at stake here, whether it's attacking Black history or LGBTQ history or feminism. I think in 2026, 250th anniversary of our country, we ought to be mature enough to hear complicated history and place it in the context of, yes, there are things that happen that are unpleasant, but it was part of a larger journey of us achieving our professed values. And that's a legacy to be proud of.
Thanks so much for joining me on the show. That's Professor Cheryl Cashin of Georgetown Law. It took less than a week for lawsuits to be filed over the EPA's elimination of the bedrock scientific finding that greenhouse gases threaten public health. The so-called endangerment finding forms the basis for regulations to fight climate change, and its revocation could unwind current air and climate rules. So a coalition of conservation and public health groups are challenging its repeal, saying the EPA violated federal law and legal precedent. More lawsuits are sure to follow on an issue that's likely to reach the Supreme Court. Joining me is an expert in environmental law, Pat Parento, a professor at the Vermont Law and Graduate School. Pat, just how critical is this revocation of the endangerment finding?
It's huge and it's ugly, and people do not fully understand just how devastating this action is going to be, not just for climate, but for public health and safety generally.
And the endangerment finding came out of a landmark Supreme Court case in 2007.
Right. So it follows on the heels, of course, of Massachusetts versus EPA, which is still the law of the land, contrary to what Mr. Zeldin thinks. And in that decision, the Supreme Court not only held that greenhouse gas pollution is regulated under the Clean Air Act, the George W. Bush administration had taken the position it wasn't regulated, and they made many of the same arguments that Trump and Zeldin are making now. And the Supreme Court rejected those. It was a 5-4 decision, and frankly, the majority in the Massachusetts case is no longer on the court. So that's what gives Trump some hope here. And then secondly, the Supreme Court said, since you have the authority to regulate greenhouse gas pollution, if you make a finding that such pollution and the emissions that cause it endanger public health and welfare, you must regulate. You don't have any discretion not to regulate once you make a finding. And the Supreme Court made it clear that was a scientific finding. It wasn't policy. It wasn't even law necessarily. It was a scientific determination that this kind of pollution is endangering people's health and welfare.
And since that point, has there been any contrary evidence to that scientific finding?
No, quite the contrary. And of course, I think we've talked before about how the Department of Energy cooked up this phony report based on 5 climate denialists. They're scientists, but they deny the consensus around climate change. And EPA was going to use that report, but then the federal court in Massachusetts said the report was prepared illegally because it was done in violation of the Federal Advisory Committee Act. And Judge Young issued a decision just recently saying, can't use this report. So now EPA has abandoned the argument attacking the science underlying the endangerment finding. There's no basis to do that. The National Academy of Sciences weighed in with a special report rebutting this so-called Department of Energy report. So the science is absolutely crystal clear, and the danger is absolutely clear. You can repeal the finding. You can't repeal the danger.
There are 2 lawsuits and counting, one by a group of youth plaintiffs and another by a coalition of health and environmental groups. Tell us about their claims that the EPA's actions are illegal.
Well, they're first of all saying that Massachusetts versus EPA is the law, and as I said, it states very clearly that EPA has the authority to regulate. So now Zeldin is coming along and saying, well, no, we've looked at it again through the lens that we use, and our conclusion is that the best reading of the Clean Air Act is not the reading that the Supreme Court issued in Mass versus EPA, but our reading, which is we don't have any authority to regulate greenhouse gases. They're using kind of an originalist argument here. They're trying to say that because the Clean Air Act of 1970 was focused on initially localized pollution, the smog that people were breathing and so forth. But it's not true that the Clean Air Act was limited geographically. We have multiple instances of where the Clean Air Act has been used to tackle long-range pollution, not just acid rain, but ozone pollution, smog pollution, fine particulate pollution that floats across the United States, from upwind states to downwind states. So this notion that the Clean Air Act was never intended to regulate anything in your immediate area of the air you're breathing is simply flatly wrong. That's never been the law. No case has ever said that. The Supreme Court has never said that. Only Zeldin is saying that. So the first argument is there really is no legal basis whatsoever for repealing the endangerment finding. And, of course, they also repealed immediately what we call the tailpipe standards, the mobile source standards, cars and trucks and so forth. They are the largest source of this kind of pollution and a lot of other pollution as well. So the notion that this isn't a significant category, that's another requirement of the Clean Air Act. You have to make a finding that there's a danger from these pollutants, but then you have to look at the sources of the pollutants and say those sources contribute to the danger. But if this is the largest source of greenhouse gases and these other pollutants, they surely contribute to the danger. So there's no legal basis, no scientific basis, and there are lots of other arguments for why this finding is not based on the law.
Particularly in light of Massachusetts versus EPA, why do you think the EPA administrator, Lee Zeldin, took this route?
Zeldin is counting on the current composition of the court. As I said, the majority that was in place in Massachusetts versus EPA is no longer there. It's much more conservative. There are 3 Trump appointees on the court. So you have to look at, can Zeldin get the court to take review of this issue and reverse Massachusetts versus EPA? So this requires basically a head count. Where do you get 5 votes on this court to overturn Mass versus EPA? You don't have the liberal wing of the court. You don't have Chief Justice Roberts, who wrote the dissent in Massachusetts, because he has stated publicly, even though I dissented, I think Mass versus EPA at this point is settled law. It's been on the books for 19 years, right? Lots of reliance on that decision, lots of regulatory actions based on that decision, lots of industry actions in response to that decision, including automakers building more electric vehicles and hybrid vehicles and so forth. So lots has happened, and there's no way, I don't think, of course it can always surprise me, but you're not going to get Chief Justice Roberts' vote. So where do you get the 5th vote? You've got the 3 or 4, perhaps, ultra-conservatives on the court. That would be Justice Thomas, Justice Alito, Justice Gorsuch, and probably Justice Kavanaugh, although even that's not sure. So where does the 5th vote come from? It almost has to be Justice Barrett. And my view is that she's not going to go along with overturning Mass versus EPA because of a doctrine that we call statutory stare decisis. So once the court has interpreted a statute, as opposed to, say, interpreting the Constitution, which can change over time, as we've seen, but when it comes to interpreting a statute like the Clean Air Act, the doctrine that that kind of precedent should not be overruled, or at least lightly overruled, is very, very strong. And I think Justice Barrett has the kind of sort of institutional integrity on the Supreme Court to respect that. So I don't see how they get Justice Barrett's vote. If they manage to get her vote and 4 other votes on the court, then yeah, Trump might win his argument that Mass versus EPA should be reversed and the decision to repeal the endangerment finding upheld. And that would have really devastating consequences because it would mean that a future president could not reinstate the endangerment finding. Once the court has determined there is no authority to regulate greenhouse gases unless Congress steps in, and that doesn't look very likely, that's the end of the ballgame. That's the end of federal regulation of climate polluting emissions. Devastating.
Pat, is there a danger in escalating this fight to the Supreme Court at this point?
Oh, I think so. I mean, it's the old adage, be careful what you wish for. If Trump is successful in getting the court to agree with him, then what happens is the Clean Air Act no longer regulates these pollutants, but that means states like California are free to do so, and you can be sure they will. California has already adopted the most stringent tailpipe standards, fuel efficiency standards in the country, and 13 other states have gone along with California. That got overturned by Congress. That's another story. But the point is, once the Clean Air Act is no longer an obstacle to state regulation, it is no longer preempting California and other blue states from regulating these pollutants, not just from cars, but from lots of other, sources as well, power plants, oil refineries, etc. That creates a patchwork of regulation across the country. Chaos, because there'll be litigation over that as well. The one thing that industry hates is that kind of chaos, that kind of unpredictability. How do you make investment decisions in a regulatory environment like that? The one thing about federal regulation is once it's in place, that's the baseline. That's what everybody can plan against, and particularly for automakers. So that's number one. If Trump wins, industry loses. Number two is the oil companies also lose because the oil companies have been somewhat successful getting state and city and county lawsuits against them for climate damage. These are the so-called deception cases, public nuisance cases, more recently climate superfund cases, and so forth. There are over 40 of these lawsuits, right? And the oil companies are making the argument the Clean Air Act preempts all of them. In fact, they're hoping that the Supreme Court takes review of the Boulder case. They're going to be in conference tomorrow on the question of whether they should take review of that case. And once again, the leading argument the oil companies are making to the Supreme Court is the Clean Air Act preempts all these lawsuits for damages. So when Trump wins the repeal of the endangerment finding on the basis that the Clean Air Act doesn't regulate these pollutants, their preemption argument goes out the window. So, there are two really bad consequences from upholding what Zeldin has done, neither of which benefits industry, doesn't benefit automakers, doesn't benefit utilities. It just creates the kind of chaos that obviously Trump thrives on, right? But the rest of the world doesn't so much.
Thanks, Pat. That's Pat Parento of the Vermont Law and Graduate School. Meta CEO Mark Zuckerberg testified this week at the first social media addiction trial, where two of the world's largest social media platforms are facing a jury trial over allegations that they intentionally designed their products, Meta's Instagram and Google's YouTube, to be addictive to young people. For 6 hours, Zuckerberg faced a barrage of questions about his company's effort or lack of effort to protect young users on Instagram and Facebook, about internal communications in which employees pleaded to shore up safety measures, and about choices he made. The trial, which is expected to run through the end of March, will serve as a critical test for thousands of other lawsuits that target not only Meta and Google, but also TikTok and Snap. Joining me is Bloomberg legal reporter Madeleine Meckelberg. Madeleine, on the whole, how did Zuckerberg do with his testimony?
So I think that Zuckerberg really stuck to the line that we've heard from Meta, from their attorneys, and from the company about the fact that they don't think that scientific evidence supports this idea that social media is harmful to young kids and can be addictive. We heard him talk about the benefits of social media and how they've tried to design their platforms to create an enjoyable experience for users and not one that's causing harm. And we heard him field difficult questions from the plaintiff's lawyer about internal emails, internal research, talking about their youth strategy at Meta and Instagram. So I think all in all, he'll probably be happy to be done with testimony. Definitely, we heard a lot of the Meta bottom line that we've heard from them for most of this case from him.
Questioning Zuckerberg was Mark Lanier, who's an experienced trial attorney and has won a number of high-profile product litigation suits against major companies. He questioned Zuckerberg about internal documents. For example, a 2015 memo where Zuckerberg said he wanted to reverse the teen trend and increase time spent by 12%. And another document that said if we want to win big with teens, we must bring them in as tweens.
Right. So those are some key pieces of evidence for the plaintiff's lawyers in this case, who you say is Mark Lanier is the trial attorney here representing the young woman in the suit. And he is quite a character up on the stand. He uses this overhead document camera and writes live notes as the plaintiff is speaking, often with a little photo of them on a piece of paper. But he showed Zuckerberg some of these documents, asked him to answer to them. And Zuckerberg was talking about how some of these metrics, he doesn't think they're valuable anymore. Time spent, for example, that used to be something that he said the company was very concerned about, but they've kind of moved away from giving teams goals on that front. And he says, quote, I don't think that's the best way to run a company based on time spent. When he was talking about some of the documents to do with teens, I think we've seen that quote quite a bit, this idea that if we want to win big with teens, we must bring them in as tweens. He says that he is being mischaracterized when it comes to that remark, and that the company has really tried to consider launching products specifically geared toward teens. They're not necessarily targeting them specifically. He stressed this idea that teens aren't really bringing in revenue to Instagram, to the companies, because they don't have disposable income. They're not clicking on ads the same way that older people do. So we heard a lot from him about how those remarks maybe represented something that was a point of discussion at one point in time, but the company has moved away from.
I understand that Zuckerberg repeated several times the phrase, "You're mischaracterizing this," or something along those lines.
That's right. And so he was trying to kind of used this moment on the stand. I mean, he didn't have a choice. He has to answer questions that are being asked, but he was trying to kind of use this moment to clarify his position or explain maybe how things have shifted over time. And I understand that the questioning at some point got quite heated, a little bit of back and forth. That's kind of something you can expect when you have an adverse witness on the stand like this being questioned, where the judge maybe has to step in and say, let them finish their answer, let them finish their answer. So definitely saw some of that from Zuckerberg's testimony.
What would you say was the biggest concession he made, if he made any concessions at all?
I don't know that I would characterize any of his testimony as a concession necessarily. I think he had some interesting comments when it came to Instagram's attempts to keep kids under 13 off the platform. That's an age requirement that they impose for people who want to create an account. But he did acknowledge, this is a really challenging problem. This is a very difficult thing to combat. There's this desire to balance kind of privacy concerns with actually enforcing this requirement. So I thought some of that commentary was interesting from him. That's something that we've seen Meta discussing in other contexts, of course. And there's this ongoing debate about whether the platforms themselves should be responsible for enforcing age requirements, or if that's something that could be done by Apple or Google in the app stores on phones before you download it. And so it's interesting to see kind of that real world conversation happening brought into the context of this litigation while he was on the stand.
So I'm interested in the questions Lanier asked him about what he characterized as extensive media training. And there was an internal document about feedback on his tone of voice, imploring him to come off as authentic, direct, human, insightful, and real, not fake or robotic.
Right. That was an interesting line of questioning. And Zuckerberg was kind of receptive to it, honestly. He says, I'm well known to be very bad at this, at public speaking. He kind of acknowledged it. And so, yes, that was definitely something that we saw Lanier flip to. And Zuckerberg said, I don't enjoy talking to the media. It's part of the job. It's an important part of the job. But yeah, definitely a very personal tone to that line of questioning.
So basically, no big surprises in his testimony.
I don't think so. I mean, this issue itself is not a new one. I think it's something we've been talking about as kind of a culture, as a country for a while, as a world, honestly. And we've heard Zuckerberg give testimony to Congress before. We've heard him and other executives at Meta speak publicly on this. So I don't think that there was an expectation that there would be a lot of fresh information or insights provided. It's significant because he's being called to the stand in this really unique case. This is the first time these novel legal claims are being tried out, because this is, one of thousands of cases. So I think there wasn't necessarily new ground tread, but there was new ground for probably many members of the jury. You have to think like an average person who's not like us and the listeners is maybe not as plugged in to some of this discourse. And so they might have been hearing some of this information for the first time. And obviously, like having a witness on the stand is a great opportunity for these lawyers to kind of help put important documents into context, because we saw Mark Lanier talk about a lot of these, like the teens into tweens and talking about youth strategy. He referenced some of them during his opening statements, but I think it's a lot different to hear that and see the paper versus see this guy that from TV and from the news talking about them and kind of explaining a little bit more about his thinking.
So something unusual that happened, the judge scolded some of the people who came with Zuckerberg for wearing Meta glasses.
I'm not sure who exactly in the courtroom was the subject of that, if they were with him or not. But yes, at one point, the judge did instruct any member of the public who's there in the room to remove any Meta glasses that they may have. The courthouse, like you might expect, is pretty strict about photos and recording during the proceedings. That is not allowed. You can't even have your phone in the room. So that was an interesting reminder from the judge, and one we hadn't heard yet during the proceedings.
The plaintiff is going to take the stand at some point. Do you have any idea when that might be?
So both parties in this case, this young woman who's being identified in court as Kaylee, she's going to have 40 hours to present her case, and then the defendants are going to have 40 hours to present theirs. So we're hardly kind of getting into that at this point after about a week of testimony so far for her. I don't know exactly when she's going to be called to take the stand. I know that we're expecting to hear from some other employees a little lower down the food chain at Meta, some former employees, executives at YouTube likely will be called. Kaylee actually was in the courtroom for a portion of Zuckerberg's testimony. We'd heard from Mark Lanier that she was not going to be making an appearance in court until she was called to testify because he didn't want to subject her to hearing lawyers and witnesses talk about these really intimate details of her life. And he kind of alluded to her fragile mental state as a result of, this alleged addiction to social media. That's the root of this litigation. But he had her there. He was asking Zuckerberg questions about her, whether he'd had a chance to review her social media feed. I think a particularly powerful moment during the testimony was he was allowed to bring out a demonstrative showing it was a large banner that stretched across most of the courtroom, and it was a collage of like thousands of selfies that Kaylee had taken and posted to Instagram. And so I think centering this case on her and reminding jurors that it is about one individual, I think that's definitely what they were trying to do with that strategy. And that's what they'll be doing when they call her to the stand and have her kind of talk about her experiences.
I know you'll be watching this case closely, so we'll talk again. Thanks so much, Madeline. That's Bloomberg legal reporter Madeline Meckelberg. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.